For years, the startup playbook was simple. Collect every piece of user data you can get your hands on, dump it into a central server, and figure out how to monetize it later. Unrestricted data hoarding was the standard engine for rapid scaling. That era effectively ended with the passage of India's Digital Personal Data Protection Act, the DPDP Act of 2023. The law establishes a hard line between two groups. Citizens whose data is collected are now data principals with distinct legal rights. The organizations collecting that data are data fiduciaries, bearing strict, non-negotiable obligations to protect it. A single verified breach instance carries a maximum penalty of up to 250 crore rupees. For a growth stage company with 12 months of runway, a fine of that magnitude results in immediate insolvency. Every unmapped or unmanaged byte of personal data on your server now functions as a direct point of financial exposure. Consider a typical, fast-growing fintech application. They process thousands of transactions a day, onboarding users as fast as their servers can handle. Right now, they capture names, emails, and financial metrics continuously. They store it all indefinitely across multiple databases, and no one on their engineering team can pinpoint where a specific user's complete data footprint lives. The founders often assume that updating a static privacy policy PDF on their website shields them from regulatory action. But under the DPDP Act, legal requirements cannot just live in a text document. They must be physically hard-coded into the startup's product architecture. Let's look at this fintech app's front door, the user onboarding screen. Historically, they've relied on pre-ticked hidden checkboxes buried at the bottom of the page to claim user consent. The DPDP Act outlaws this practice. Organizations must now establish a specific lawful basis for collection and provide a clear, plain language notice exactly at the moment the user hands over their information. To execute this, the pre-ticked box must be replaced by a technical consent manager. When a user agrees to share their data, this gateway captures the exact terms they agreed to and stamps the payload with a digital timecode and a unique ID. This system performs three mechanical functions: capturing the agreement, securely storing the audit trail, and allowing the user frictionless withdrawal of their consent at any time. Without a verifiable technical consent architecture stationed at your front door, all downstream data processing is legally poisoned the moment it begins. Moving past the front door, we enter the fintech app's internal database. Currently, it's a tangled web where sensitive user details are mixed freely with basic operational metrics. This violates two core DPDP obligations: data minimization, which means collecting only what is strictly necessary, and purpose limitation, which restricts how that data is used. To fix this, the startup must execute data mapping. This process forces the engineering team to locate, categorize, and isolate every piece of personal data flowing through their infrastructure. Once mapped, the data requires strict security upgrades. This means applying AES 256 encryption for data at rest and implementing role-based access control so that employees only see the specific data permitted by their job credentials. Organizing and aggressively restricting internal access like this doesn't slow down the team. It builds an auditable foundation that actively prevents devastating insider breaches. Finally, we reach the end of the data lifecycle. Most startups treat their servers like permanent storage lockers, holding onto user records long after a customer has churned. The law dictates storage limitation. Personal data cannot be retained beyond the period necessary to fulfill its legally stated purpose. Relying on manual cleanup guarantees failure. You need automated deletion workflows that programmatically destroy or anonymize data the moment its retention window expires. Systematically destroying excess expired data is the single most effective way to proactively eliminate your compliance risk. You cannot leak what you no longer hold. Look back at our fintech app. They now operate a clean, mapped, encrypted, and strictly governed system. But even with a perfect architecture, threat actors evolve. Breaches can still occur, which brings us to the final obligation: incident response and breach detection. If a breach happens, the law demands a strict, immediate notification sequence. The startup must simultaneously alert the Data Protection Board of India and directly inform every affected user. Completing this entire privacy stack elevates a startup to a state of regulatory resilience, where a breach triggers a controlled response rather than a company-ending disaster. Overhauling your entire infrastructure all at once is a terrifying prospect for founders who cannot afford to stall critical product engineering. You prevent engineering bottlenecks by adopting a phased, documentation-first compliance approach. We call this the 4-phase roadmap: assess, design, implement, and validate. Phases 1 and 2 focus on mapping your current data flows, writing the retention schedule, and officially assigning a grievance officer. You figure out what you have and design the rules for how to treat it. Phases 3 and 4 shift to execution. This is where you deploy the technical controls, the encryption and consent gates, and finally conduct third-party audits to prove your system works. Building toward DPDP compliance streamlines enterprise sales cycles and provides investors with a clear, low-risk roadmap during due diligence. Safeguard your startup's growth trajectory today. Partner with Second Quadrant Consulting Solutions for a DPDP readiness audit and build a resilient foundation